So I'll just read the statement and then we proceed from there. So the Law Society of Kenya has a statutory mandate under Section 4 of the Law Society of Kenya Act to protect and assist the members of the public in matters relating to, ancillary or incidental to the law, as well as uphold the Constitution of Kenya and advance the rule of law and the administration of justice. We have in the recent past witnessed events witnessed events which portend a grave danger to the rule of law and the administration of justice, and which must be addressed immediately if we are to maintain faith in our institutions. The Office of the Director of Public Prosecutions under Article 157 of the Constitution is an independent office and exercises the power to prosecute on behalf of the public. In exercising his powers, the DPP shall have regard to public interest, the interest of the administration of justice, and prevent and avoid abuse of the legal process. We have witnessed a spate of withdrawal of cases facing various suspects, and some of whom have been nominated for appointment as cabinet secretaries. The profile of the suspects invites significant public interest as to the motive of the discontinuation of the cases, and further poses serious credibility concerns in the investigative capacity of our institutions. The Law Society of Kenya is alive to the fact that before any prosecution is commenced, the DPP reviews the file under the decision to charge guidelines and only approve the charges if the investigations reveal a probable case against the suspects. This is a sacrosanct duty that the Constitution placed upon the office of the DPP to ensure that the public interest is protected and the criminal process is not used for other motives. We are therefore alarmed by the recent decisions by the DPP as they point to either two very disturbing scenarios. One, that the prosecutions were mounted for ulterior purposes whose end have been achieved or overtaken by events, or two, that the DPP has withdrawn the cases to aid an ulterior motive. The Director of Public Prosecution therefore owes the country an explanation as to the reason informing the discontinuation of cases. If the cases are being withdrawn for lack of evidence to sustain the charges, the DPP must take responsibility and explain how the decision to charge was arrived at in the first instance. We all recall that some of those suspects were arrested in somewhat dramatic situations with media press releases as to the reasons for their arrest and arraignment in court. However, the discontinuation of charges have been done silently and without any press release from the DPP. The Law Society is also aware of the frosty relationships between the former Director of Criminal Investigations and the DPP, as well as the sustained efforts by the DCI to prosecute cases without the consent of the DPP. The Society therefore calls on the DPP to publicly reveal the reasons for the discontinuation of the cases if the public are to restore confidence in the office of the Director of Public Prosecutions. We similarly call on the judiciary, and especially the magistrates handling the cases, to insist on the DPP providing credible and cogent reasons before allowing the discontinuation of the charges. This is to assert the independence of the judiciary and prevent the courts from being an arena for settling scores and abuse of judicial time and resources. We've also similarly noted a disturbing trend at the Public Service Commission, which under Article 232 of the Constitution is required to ensure transparency and provision to the public of timely, accurate information, as well as ensure fair competition and merit as the basic principle of appointments. The Law Society notes that the Commission recently shortlisted about 477 candidates for the position of permanent secretaries, and without any credible explanation, expanded the list by another 108 candidates in a manner that speaks to taking instructions from other quarters and renders the ongoing interview a sham and a public relations exercise. The Law Society has also noted with concern comments and deliberations made by the Deputy President that evictions shall only be enforced after clearance by the sub-county security committees. This amounts to subjecting court decisions to the whims of the security committees and renders court adjudicative processes ineffective. Ultimately, this will encourage a culture of land grabbing and impunity and is a serious threat to the rule of law. The laws of the country have adequate provisions on how evictions are to be carried out. The courts have also delivered several decisions on the manner of carrying out evictions. The roadside declarations by the Deputy President cannot therefore substitute the law, and we urge the Deputy President to withdraw his remarks and uphold the rule of law and the Constitution, which he took an oath to protect. The Law Society also wishes to point out to members of the public that the courts have stayed the establishment of the office of the Chief Administrative Secretary. Therefore, unless the court orders are vacated, both the government and the public should refrain from participating in any actions in breach of the court order. We remind the public that in giving ourselves the Constitution, we resolved to have the rule of law and fidelity to the Constitution as our constant true north. We therefore must protect and uphold our Constitution at all costs, otherwise we invite anarchy and chaos. Ladies and gentlemen, that marks the end of our statement. We can, with regard to your question, I think we have to wait and see if the Director of Public Prosecutions will come out and give an explanation as to the reasons leading to the withdrawal of those cases. In the event that he does not, then we still have several recourse to one, either reviewing the evidence in those cases, and if we find that there is credible evidence, we can mount private prosecutions. But similarly, considering that the DPP has withdrawn most of those charges under Section 87 of the Criminal Procedure Code, he can, in the event that he is now claiming that there was lack of cooperation from the investigative agencies, then he can resubmit those files back to the investigative agencies to seal the gaps, which is what he should have done in the first place. So that he needs to, with immediate effect, resubmit those files, direct the Director of Criminal Investigations or the IG on the areas that and gaps that needs to be sealed, so that if there is credible evidence, then the prosecutions should be mounted. But the question that should concern all of us is this, is that who then can trust the police? Who then can trust the DPP? Because if the DPP can charge someone without a proper basis, how then tomorrow can we say that he is exercising the functions of his office independently and for the purposes for which the office has been set up? That should be the question. When our police investigate cases and they come and tell us that in that case we did not find sufficient evidence to prosecute, will we believe that they have actually conducted proper and thorough investigations if it turns out that these cases that they were taking to court, they were taking those cases to court for other purposes other than nabbing suspects of corruption? That is the dilemma that we face as a country. And so therefore, it is incumbent upon the Director of Public Prosecutions to come out and explain to the country what is the reason that is motivating the withdrawal of these charges. Otherwise, we are left at a place where, as a country, we are assigning improper motives in the withdrawal, and we are left with a very reasonable presumption that the only intention of withdrawal of these cases is to ensure that those who have been nominated for various positions in the public service, the hurdles that are before them in the form of those cases are eliminated.
The question I was asking, because of the mandate is stated that LSK stands to execute, is there a time frame? Because it just says that in the event it doesn't come out, you might consider private investigation, but maybe the country want to know if you are giving him 1 day, 2 days, a whole week, a month, the time frame that he should come out and explain.
We will take that one. You can rest assured we will take the appropriate action if the DPP does not respond to our demands, because we have in law several options that we can pursue to ensure that we get accountability in terms of how he has exercised the decisions that he has made in the cases that have been withdrawn.
What my colleague is asking,
you see, we are now probably, and this is what we are trying to avoid, to get into a situation where we want to imagine what may have led to the DPP or the kind of pressure that the DPP had. If he tells us that I charged these people because I was under political pressure, then there'll be attendant consequences to that admission. So I think that we should wait until the DPP gives us his explanation. And I know in certain cases he has probably given what we consider to be extremely weak reasons as to why they may have withdrawn certain cases, we need to examine the reasons for which he is saying he has withdrawn those cases, with a view to determining whether indeed they are cogent reasons. Because if they are not, then the only reasonable presumption would be that the intention to discontinue those cases was to clear the path for these candidates to get into public service.
Yeah, question. Mr. Chair, you have raised very critical issues about the performance of the